Hi everybody, thanks for coming. This is the presentation about the Ohio laws that are more family friendly than people know. I'm Bai Macfarlane and our Ohio outreach is Pro Families Ohio. Anyone can look at the website, and Pro Families Ohio is a work of Mary's Advocates. When I publicized this presentation, I said we were going to be talking about the Ohio laws that aren't implemented, that are actually more family-friendly than people know. And we probably all know somebody that has been served with divorce papers. And people say, if somebody wants a divorce, there's nothing you can do to stop it. Well, if we follow the Ohio law, that is actually not true. And here's why. I have some information cards that just go through three of the primary laws that could help a person who wants to keep their family together. But before I go into that, I want to talk just a little bit about marriage in general. And as ridiculous as this is, it helps me use visuals. So this is a lady and this is a man, and we're going to call them Jack and Jill. And when Jack and Jill marry, they only marry because they agree to certain things. And for centuries, and presently in Ohio law and in common sense, people marry because there's certain expectations they have before they would want to have and start a family. That's one of the things having to do with marriage. So when they marry, there's like, hey, I want to have children with you, and I want to be with you for a long time, and I love you, and I want to be together. But I only want to have children with you if I can raise those children and I can be a part of those children's lives forever. I mean, this is kind of common sense, but part of marriage is I want to be sexually faithful to you and I want you to be sexually faithful to me. Another part, in Ohio law, marriage is defined as a contract that has three elements: respect, fidelity, and support. So Jack and Jill, when they get married, according to Ohio law, they are contracting towards each other to uphold the obligations of respect, fidelity, and support. So that's what they expect when they get married. This little white bin represents they're now married. Now there are certain circumstances that are so grave that according to Ohio law, and I'm going to say common sense, it's such an offense against marriage that there might be a fair reason to be separated. Now, for example, say one of them doesn't uphold their obligation of fidelity and someone's out having sexual relationships with other people. That's simply, in Ohio law, it's called adultery. And that's a reason in Ohio law for divorce or separation. Another one is, say they're not upholding each other's obligations to be respectful at all. So someone who's gravely abusive, that's a reason for divorce in Ohio law. Another reason is extreme cruelty or gross neglect of duty, because they promise to support each other. If they're grossly neglecting their duty, that's a reason for divorce in Ohio law. And I say it's a reason in common sense that you need some help because one of the parties is not upholding their obligations, and we use the court system to help make that situation better. Now, decades ago, there was no such thing as no-fault divorce, and in order for a court to have jurisdiction to issue a divorce decree, somebody had to show and prove that there was fault, like one of those things I just gave examples of. So if Jack is committing adultery all the time with somebody or other, well then Jill has a grounds for a separation and divorce. That's how it used to be in the old days. But what was happening in the sexual revolution, and even before that, is sometimes couples wanted to split up. And what was happening is both mommy and daddy wanted a divorce, but the court had no civil jurisdiction to issue a divorce unless there was a fault-based ground. So what was happening, and I learned this by, anyone could go study, there was a Uniform Divorce and Marriage Commission that was meeting every year, and you can go read the transcripts of what they were talking about, and I'm just giving you some pointers of what they were talking about. So if Jack and Jill both decided we don't want to be married anymore, now someone may have moral disagreements about that, but just strictly speaking for Ohio law and civil law in general, if they both decided they wanted to get out of the marriage, no-fault divorce would allow them to do that. But what happened in Ohio is that the legislators said it takes two people to get into marriage. So we're not going to be like these other states like California, which was the first one that enacted no-fault divorce. I've got records from the discussions of the Ohio legislators who brought in no-fault divorce, and they said in Ohio, we're not going to be like California. It takes two to get married, and it's going to take two to divorce unless one can prove grave fault. And what this is in the law, in a very simple way, if Jill is just emotionally distant and annoyed with Jack, the only way she can get a divorce from him is to prove he's extremely cruel, grossly neglecting his duty, get him to agree that he wants to be divorced, or they could be separate and apart for a year. That's a ground in Ohio for divorce. But in the criminal code, being separated when the other person wants you to stay, that's a first-degree misdemeanor. And what happens when people say, oh, you can never stop a divorce, is no one's paying any attention to the law that abandonment is a misdemeanor. So if we were following the Ohio law, and I'm looking for lawyers who would be willing to help clients do this, if Jill is really annoyed with Jack, she goes and files for her divorce. She says, I want a divorce because we both want a divorce, which in Ohio is just saying you're incompatible. Well, if Jack says, no, I don't want a divorce, I deny incompatibility, well then Jill has just lost that basis for divorce. Am I making sense? Or do I need to repeat it? Are we okay? Okay. So she files for this divorce. She uses the no-fault ground in Ohio, which is incompatibility, if not denied. He denies it. So now the court doesn't have jurisdiction to issue a divorce anymore, unless they can use the fault-based grounds, or unless they're separate and apart for a year. If Jill goes and lives with her new boyfriend that she met at work, but Jack hasn't done anything extremely cruel, grossly neglecting his duty, or any of the other lists for separation that are fault-based grounds, legally, Jill is a criminal abandoner in Ohio law. And these are the laws that I'm trying to get enacted. They've already been enacted. I'm trying to get them implemented. Another thing is, let's switch it around. Let's say Jill works part-time, she has 3 kids, Jack is emotionally distant and just tired of Jill. I mean, everybody's marriages have issues, but I'm talking about nothing serious, nobody's committing adultery, no one's gravely abusive, but Jack's just had it. He's really annoyed with her, blaming her for everything. We've all heard these stories. So Jack files divorce against Jill. Well, if she denies incompatibility and they're still in the same house, Jack has this issue where he doesn't have any grounds for divorce unless he can prove she's extremely cruel or grossly neglecting his duty. So instead what he does is he moves out of the house. And she's financially destitute because Jack was making more money than Jill, and she's relying on his help. Well, let's go back to what they did when they decided to get married. Jack and Jill agreed, respect, fidelity, and support in Ohio law. If Jack bails, and he's not doing the support that he agreed to or that he had been doing month after month, year after year, and Jill is in trouble, Jill can get help from someone else temporarily. And then she can file a suit in common pleas court. You know, say her mom has some money. Say her mom helps her pay her car lease, her mortgage, her phone bills. Mom's helping buy groceries, grandma for the children. Grandma and mom can go to the common pleas court and say, we need you to order Jack to fulfill his obligations for necessaries. And they just bring, this is what the law says. These laws exist on the books right now. What's happening instead in no-fault divorce is that when one party files for divorce, sometimes the defendant's lawyers don't tell them about these laws. Sometimes the defendant's lawyers don't even know about these laws. Sometimes they coerce them into agreeing to a separation plan that they don't really want, but they're just told. Like, Jill could be told by her lawyer, well, the only way you can get money from Jack is we need to file a divorce or a separation, and you need to agree to a plan. And then they have pretrial meetings, and people go down to pretrial meetings. It's not like you see on TV where you have everyone around a table with a judge in the room, at least not in Cuyahoga County. They have these long hallways. People are sitting at opposite sides of the room, opposite sides of the hallway, in benches. Jill will be sitting with her lawyer, Jack will be sitting as his lawyer. Both of their lawyers will go in and have secret meetings with the judge where the parties aren't allowed to be there. And the objective, this is just from what I've heard. If you know people who've gone through divorce, ask them if I'm right. The objective is for the lawyers to get the parties to agree to a divorce. Because if they don't agree, then the judge has to do work, and she has to do judgments, or he has to do judgments. Judges would prefer that the parties settle it themselves. So there's all this coercion going on, but Jill is never told, you don't have to give the court jurisdiction over your children, because when someone files for divorce, the person who files for divorce, he's saying, you know, I want the court to decide what happens to my kids. Because when you go to the court, you've given the court power to make decisions about parenting plans and custody, and these things are giving the government jurisdiction over your children. But if Jill is a defendant in a divorce and she didn't want it, she never gave custody of her children to the court. She never told them, I want you to make decisions about my children. She's like, hey, I'm home minding my own business, and all that's happening is Jack is not upholding his lawful obligation to support, and we need to use common pleas to help us. This is what I'm trying to do with Pro Families Ohio. I'm trying to educate people about these laws, and I'm trying to find lawyers who will help clients, because sometimes people call me or email me, and they say, Bai, do you know any lawyer that's willing to help me? Because if you go with a routine divorce lawyer, I'm sorry to say, but I think it's coercion. They tell the parties, you've got to agree to a divorce. The judges will say to the person that comes in, you know, look, you are going to be divorced. There are rules about how many months they have to process a divorce. So Jack's filed his divorce 1 month, and the judge says, well, if you have children in 18 months, Jill, you will be divorced. It's the process that's happening right now, and that's the status quo. Let me see if I've covered everything about these laws. Marital abandonment is a first-degree misdemeanor. Oh, if someone commits a misdemeanor because a third party aided, abetted, talked them into, coerced them, the third party is also committing a crime. That's called complicity. So Jack is tired of his wife. He's annoyed. Jill's not doing anything extremely cruel or grossly neglecting his duty. If Jack files for divorce and Jill denies incompatibility, he doesn't have that ground. The only ground left he can try to do is prove her doing something she didn't do. And then he's left with being separate and apart for a year. But that's a crime. If his civil lawyer tells him, well, you know, the only way we're going to get this divorce is if you live separate and apart for a year, because Jill here is just expecting you to uphold me. The lawyer's not going to say it that stupidly. But what I'm getting at is, if abandonment is a first-degree misdemeanor and she's not doing anything wrong, and he leaves, he's committing an abandonment, a crime, but the lawyer who instructs him to leave is committing another crime of complicity. Like, the legislation in Ohio didn't intend marriages to be broken up when one party needed the other spouse to uphold their obligations. Let's see, I talked about getting necessaries, I talked about denying incompatibility. That is the three main ones I want to point out. I want to talk about some of the people that I've known over the years as I've been doing research with Pro Families Ohio. I know of a case where the wife is very annoyed at the husband. I was talking to the husband over a long period of time, and he was explaining to me that the wife went to court and complained, without the husband there, that she wanted the husband kicked out of the house. And there really are lawful, the courts have the authority to kick someone out of their house. The sheriffs will come and show up at his door and say, look, you've got 20 minutes, we're going to wait here because your wife says she's afraid you're going to do something terribly dangerous and beat her up, and we're going to get you out of your house. So he's got 20 minutes, 3 hours, whatever. He's got to collect with his green garbage bags as much as he can get, and he's got to leave. The court will order that to happen, and the sheriffs will tell him this. But because this is such a serious matter, he's going to have a hearing really fast. And I forget if it's either 7 days or 10 days that he can have a hearing in front of a judge where he can defend himself with a lawyer helping him. And if she can't prove anything, then these temporary orders kicking him out of the house get revoked. So he can go back home. But I know 2 men who had this happen to them. And the one guy, even though he was shown to have not done anything meriting the forced eviction, no one told him he could go back home. It's really sad. I talked to a police officer and asked him about this, and the police officers were like, I don't know. I don't want to get involved, this domestic relations stuff. It's like people are, we can only guess why they're saying what they're saying. Another thing, the attitude about the courts and their paid professionals towards the Jills of the world that need her husband to do what he promised to do. The attitude of the court towards her is very sad. And what I mean is, the people who work, this is from what I've heard from defendants, the people who work in the divorce courts assume he has a right to his divorce. Everyone who's tired of their marriage has a right to their divorce, and they have a right to a no-fault divorce, because the way Ohio law is and a lot of other states' law is, they say the law says that when they split up the property, they can't consider marital fault. So say these people have a house together, I don't know, say they have a $200,000 house, let's say they've got $180,000 into the house already, they've been living together for 20 years, their house is mostly paid off. So what the court will do is say, well, divorce, he gets $90,000 worth of the house, she gets $90,000 worth of the house. The bank is still owed, I think it's $20,000. So how do you split a house in two? What happens is the children lose the house because the court doesn't consider marital fault. Just because he's an abandoner committing a crime of abandonment, the civil divorce court won't acknowledge that, and they'll just say we have to split the house in half. So there's lots of children that are losing their houses, or their houses are going into foreclosure because this Ohio law, well, this practice in domestic relations court, where one spouse is actually committing a crime of abandonment, and the courts will force the property to be split, but they can't consider marital misconduct, which I say abandonment and adultery is a marital misconduct. Another thing, when they go to their first pretrial meeting, the lawyers, if they have children, if they have children, you know how I said earlier that if he abandons the marital home and files for divorce, he's given the court jurisdiction over the kids. Well, the way they do that is they assign a court-appointed psychologist, and they assign a children's guardian ad litem, and they assign a children's lawyer. All these people are mandated by the court to get involved in telling what happens to these people's children, even though she never asked for it, and the court will order them both to pay for it. So she's minding her own business. She's sad her husband's abandoning, and some guardian ad litem or children's attorney comes in, and he now starts having, the children legally, they become his wards. I mean, I think of Batman and Robin, you know, Batman's ward was Robin. He was the one responsible for what happens to Robin, because I guess Robin was not an adult yet. But this is what it legally is. So because he abandoned the marriage and filed for civil divorce, her children just became wards of some court-appointed guardian ad litem. I think that's gross. You know, you might think it's gross too. It's like, why should her children have to be given under the control of someone else? And then they ask them, and then they also assign these court psychologists. And what happens to Jill is she's told by these divorce professionals who earn their money in the system that, you know, what's wrong with you? Why do you want to stay married to someone who doesn't love you anymore? Or we can't force him to stay married, or we can't force him to want to be married. And just think about the logic of this. Marriage is a contract. Contracts happen when he might have made an offer. Hey, Jill, will you marry me? She considers it. If they're married in a church, a lot of churches require some kind of marriage preparation investigation. So they're like meeting with a minister who says, you know, are you sure you want to do this? And are you all suited? And do you understand this was permanent? And you're going to come to me if you have problems. She considers it before she says yes to the engagement. They both consider it before they say yes to the wedding. And then when they consent to the wedding, Ohio law says they've just entered a contract where they agree, respect, fidelity, and support. And that's just for the people who don't have church weddings. The church is a whole other subject, where people who have a church wedding might have a different set of obligations to which they agree to adhere. But that's more of a discussion that's going to deal with the constitutional problems. Well, anyways, Jill is told by these professionals, what's wrong with you? We can't make him stay married. And all she's really doing is saying, I'm just asking him to uphold the obligations that he agreed to uphold before I consented to marriage. I need to check something here. Yeah, we're still good. Um, and then people act like this is normal. Imagine some other contract. I use an example of a car lease. You've got a car lease? Well, and you have a contract with the company. The car dealer agrees that you use our car, and you agree you pay the money. You're relying on the car. You need it to get to work. Your kids need it for whatever. So what would happen if the car dealer went to the court and said, I'm just really annoyed with Bai Macfarlane. I don't want her to have our car. Will you please order that I get the car back? And then the sheriffs come and they take the car away. But Bai still has to pay the lease. It's lunacy. But in marriage, people act like it's normal. So you get the gist of what I'm talking about. This is the position of Mary's advocates with Pro-Family Ohio, that we need to be able to say to a judge, look, Jill didn't do anything extremely cruel or grossly neglecting the duty. He's an abandoner. The divorce case should be dismissed. She should have her day in court where he tries to prove extreme cruelty on her. And extreme cruelty, according to the case law I've seen, is it's when she's deliberately doing something. It's a thought crime where she's deliberately doing something to cause him harm. And how do you prove that anyway? But that's another issue for constitutional problems too. But he can't prove this against her if they're doing it fairly, because it's just plain not true. So the guardian ad litem and the court psychologist should not be making decisions about what happens with Jill's children. Jill should be left alone with her children. And if he's an abandoner, think of some other crime that someone might commit. The example I think of, I don't even know if it's criminal trespassing, but say your neighbor was really annoyed at you and they parked their car perpendicular on your driveway. I'm sure there's something illegal about that. So if you went to court and said, he keeps parking the car on my driveway perpendicular, I can't get to work, I'm messing up my lawn, I want him to stay off my driveway, the judge in a criminal action, let's assume it's trespassing, but I'm not sure. In a trespassing case, the public would expect the judge to say to the neighbor who's doing stupid things with his car, you can't do that. Stop doing what you're doing. This person has a right to their space. You're obligated to keep your car in your own yard. But in divorce, right now on the books, abandonment is a crime. If she, all her friends, the pastor where they got married, her mom and dad, maybe even his parents, who knows, if they all file a complaint in municipal court with the police, they write the complaint up, he's an abandoner, the way the law is written, a judge, if the judge is doing what the law says, should be saying to this husband, look, just like the judge should say to the guy who's putting the car in the wrong spot, you've got your obligations to uphold, or the car dealer that says, I just really don't want to leave Bai the car, the judge would say, you're out of your mind, you can't just take the car away. The judge could say to the abandoning husband, look, you guys have got a contract for marriage, and in Ohio, marriage means fidelity, respect, and support. What you've done is first-degree misdemeanor abandonment. You have got to stop being an abandoner. And if you continue to insist obstinately on being an abandoner, the law says I can put you in jail and I can fine you money. You're hurting the culture. This is not good for the community. So that's the laws that we're trying to educate people about. I want to split over to something different now, which is not unique to Ohio law, but is just constitutional problems with no-fault divorce in general. And I'm thinking about other states. When no-fault divorce swept through the whole country, a lot of states said if one party comes forward and says we have irreconcilable differences, or our marriage is irretrievably broken, or we're incompatible. A lot of states said if one party alleges that that's the situation, then the court does have jurisdiction to force a divorce. And divorce does four things. It will split the property. It will split the children. Someone's going to get custody. There's going to be some kind of parenting plan. They might do shared parenting plan. Someone may or may not be ordered to pay some kind of support, which could be alimony, spousal support, or child support. And both parties are free to enter a new civil marriage. That's what divorce does. Splits property, splits children, someone might have to pay support, and they're both free to remarry again. And I've got here a list of constitutional issues about this. And this is on, it's not on the Pro Families Ohio webpage, it's on Mary's Advocates, our parent organization's website, under Divorce Unconstitutional from the left menu. Standing in a civil matter is lacking. The plaintiff alleges no injury caused by the defendant. And I've only done research on this, so scholared lawyers will be able to know more in depth what I'm talking about. I'm just covering at a very high level. When someone files a complaint, let's switch it now. I need a third person. Okay. Here's the neighbors, and here's the issue with the car. He keeps parking his car in his driveway. Red tie here. Red tie files a complaint in a civil court saying he's doing something bad to me. And he has this red tie has standing in the court because he's alleging that this guy did something bad to me. If this guy is not affected by anything bad this guy's doing, he doesn't have standing in court to even bring his issue. Well, what happens in divorce, in a no-fault state, he goes to court and says, our relationship is irretrievably broken. That doesn't mean she did anything wrong. In law, there's no standing if we're looking at this standing issue, because he didn't accuse her of doing anything particularly wrong. So that's one of the constitutional problems that someone could raise if all the things lined up and someone wanted to. Due process is missing. Innocent defendants are deprived of fundamental liberties, property, children, and sometimes they go to jail because they don't follow the orders. But no governmental interest is shown as served. You know, in the Constitution or the Bill of Rights, it says we have certain rights, life, liberty, and the pursuit of happiness. Some of these rights are so fundamental that state governments aren't allowed to take the things from you unless they can reach a certain level of scrutiny. And the name is slipping me, but the kind of scrutiny that's required for taking stuff from people that is their fundamental liberty in the Bill of Rights is a high level of scrutiny, and the only reason they can still take it is if they show it's in the best interest of the state to do it. One example I think of, well, let's say the driveway thing. Red tie is annoyed that he's putting the car in the driveway. This guy could be ordered to pay money as a fine if he puts the car in the driveway. But the legislators have decided, you know, it's good for the state that we don't let people go block each other into their driveways. So they're taking his money, but it's good for the state. Well, in this situation in divorce, if she's sitting home and a court is going to order that her children spend overnight visits and leave the house, and she never asked the court to have control over the children, the court is taking away her right to parent her children, which is a really, really fundamental right. But where are they showing that it's in the best interest of the state to take away her children when she hasn't done anything wrong? That's the issue. That's the constitutional problem, that they're supposed to have a high level of scrutiny when they deprive somebody of fundamental rights. Or other cases I've heard of, a lot of times the guy's an abandoner, or switch it around, the woman's really annoyed with her husband. She'll file. I know of, and we all know of normal men. Yeah, they're not, Prince Charming, but they're just normal guys. They're our brothers, they're our dads, they're our neighbors, whatever. And their wife wants a divorce. These guys, they lose their children most of the time, and they're ordered to pay a lot of spousal support or child support. Their money and their kids are being taken from them, but they've never been shown. When did all of the voters in Ohio or all the people in the United States say, this serves the best interest of all of us to take children from an innocent dad? That's what's going on with no-fault divorce. So that's the other constitutional challenge, is this level of scrutiny. The state should have to prove why it serves the best interest to take this dad's children from him. Equal protection is lacking. In the case of the contract, let's go back to my original, he's annoyed and an abandoner, she's doing nothing severe. in the case of the contract, they're not getting equal protection. He's getting the right to just ignore his contract, but no one is protecting her right to have the obligations upheld. That's not equal. Another one, state interferes with intended obligations of parties in a contract. Parties intend to uphold obligations defined. Now, on a minimal level in Ohio, I told you that marriage is defined as contract of respect, fidelity, and support. Well, there's a whole population of people who enter religious marriages. And when they enter religious marriages, if somebody commits adultery, that's a grave offense against the marriage. And they're only supposed to have separations that would be in accord with Christian principles. The Catholic Church has their code of canon law. Bible-believing Christians could use, I think it's John 6, but it's the part where it talks about how when you guys have disputes among yourselves, you Christians, you shouldn't be taking your problems to the civil forum. You should be handling them yourselves. I've been on radio here with a pastor who has ecclesiastical elders, ecclesiastical council, where people do bring complaints about conflicts to this ecclesiastical council, and they come back with answers. So when I'm going back here with this, the state is interfering with intended obligations of parties in a contract. If these people had a religious marriage and they were in a pure no-fault state, and he does what he's abandoning, she could still say, look, we entered marriage, and the obligations of the contract that I considered before agreeing to have children with this man and starting a family, the obligations of that contract are defined by our religious rules. Just like the electrician who put the lights in this room, I'm sure the subcontractor and the contractor had something where the electrician agreed to do the power setup according to some kind of electric code. Well, parties who marry in a religious marriage, they agree to uphold their obligations defined in a religious code. Just because it's a religious code doesn't mean it has no weight as a contract. And the issue is that the U.S. federal Constitution, I want to say Article 10 in the Bill of Rights, says that states can make no laws infringing on the intended obligations of parties in a contract. So when a state forces on her an outcome in a separation or divorce that is contrary to the obligations he agreed to when they got married in the first place, the state is infringing on the intended obligations of parties in a contract. That's against the Bill of Rights. So that's one we could raise. Civil judges cannot interpret parties' church law that applies to a divorce case. If they had a marriage contract where they say going in, any marital disputes are going to be managed in accordance with the rules that we decided on, like Church Catholic Code of Canon Law or some elders panel, if that's what they decided, then the civil government has no competence to be interpreting how their contractual religious rules apply to their marriage. That's another constitutional issue that a question could be raised in a real case. Here's one. Religious liberties are violated when clergy are criminalized if clergy solemnize religious weddings and don't require parties to get a state marriage license. And what I mean is, say you live in Washington State. I know that their state is one of those states where if one party says we're incompatible, the court will order an innocent husband out of his house permanently. They don't care whether he's guilty of anything. They'll do it. I mean, I've seen video of it being done. If you live in that state, and let's say all the Christian pastors and Catholic priests said, this process that you do to married people is an abomination against our religion, and it's an abomination against the contractual obligations that they accepted, and we saw them accept them when we had our big wedding in our church. If the pastors recognize this problem, the state, the pastors might say, we want to bow out of this civil marriage stuff because it really doesn't have anything to do with real marriage, because civil marriage means that anyone can get a no-fault divorce and get ordered out of their house when they didn't do anything wrong. Am I making sense? Should I summarize it more? Okay. If the pastors recognize that no-fault divorce marriages are nothing like the marriages that these parties intended when they got married, if the pastors recognized that, they might want to bow out and not have people get civil marriage licenses, because the state pretends that if you have a civil marriage license, then they just assume that you've accepted the obligations they equip with marriage, which includes all this power to the divorce court. What the state does right now is, if a minister was to conduct a religious marriage for these two people and they don't get a state marriage license, the minister is committing a crime. And that's what I'm talking about, that this is a huge violation of religious liberty. If someone wanted to enter what they considered a marriage, and the state says it's a crime for you to do it because you have to do our kind of no-fault marriage, that's another one. Religious liberties are violated when a party is forced to undergo divorce proceedings and follow orders that violate their religious belief. I haven't explained anything up to now as to how I got into this work, but I think I will right now. I got into this because I was like Jill here, and my husband wanted a divorce, and we're in Ohio, and I didn't know what I know now about the law. That's why I started this nonprofit educational organization. The court psychologists are, at least in my case, they assigned a court psychologist. And I have with me an excerpt from a report. The court psychologist met with me, and we had 4 children. Our youngest was now, I think he was like 4 years old looking at this. This is an excerpt from her report. Because the court psychologist gets assigned, she gets paid thousands of dollars. The court will order the parties themselves to pay her, so I had to pay a half of these thousands of dollars that went to her. And I was in a meeting with her and our kids. And this was after our youngest was put in daycare by my husband. I had been a stay-at-home mom. None of our kids had been daycare. I was really blessed and glad to be able to do that. So we're in her office, and this is an excerpt from the report she wrote to the judge about the encounter. So the judge says, "The following is an addendum to my original support submitted on such and so date. I also submitted another report. Of central importance in this matter is Ms. Macfarlane's, that's me, unwillingness to accept the divorce. It's her conviction that marriage is a binding contract, and she strongly asserts that her husband has violated this contract, tearing their family apart. The youngest child, Cletus, is enrolled in a combination daycare preschool. His father reported that he has not had any difficulties with the adjustment. Ms. Macfarlane feels it is unnecessary that her youngest child is in daycare, considering the fact that she is home during the day. During her visit with Cleet, she asked him," so here we are, there's 4 kids, I have Cleet, there's a court psychologist. I asked Cleet so that she could hear how Cleet talks. I asked him, "Where would you like to be during the day? School, mom's house, or dad's house?" And now remember, up till this point in Cleet's life, he was with me all the time because I was a stay-at-home mom and his dad worked outside the home. So Cletus responded that he would like to be with his mother. Bai, that's me, also asked Cletus in my presence, "Why aren't you at my house anymore?" Cletus responded, "Because Daddy broke up our family." So this is the court psychologist's report to the judge describing this conversation that I had with my son in her office. And in her summary and conclusion, she says, "It's obvious that Mrs. Macfarlane cares deeply for her sons and is passionate regarding her beliefs towards their education. I understand that this divorce has been very difficult for her. It's problematic, however, that Ms. Macfarlane continues to promulgate ideas in her children. Of great concern are her interactions with Cletus in my office. Specifically, she encouraged Cletus to state that his father was breaking up the family. Also of great concern is the fact that Ms. Macfarlane appeared to view this as a positive. She has not demonstrated that she has an understanding of how this is potentially very damaging. While it is in the court's purview to determine visitation, it frightens me that she seems to have learned very little about children's adjustment to divorce based on her unwillingness to accept this divorce. I do not see any problems with Ms. Macfarlane having unsupervised overnight visits with her sons, provided she ceases from promulgating negative views of their father." So when we ask what are these negative views that the court psychologist is complaining about, she's complaining that a 4-year-old said, "Daddy is breaking up our family." And for me, I got married in a religious tradition that thinks that abandonment is wrong. And I'm teaching my children what my church says. But this is what she writes about me. And this was even before I knew that abandonment was a crime in Ohio, so it's even more ridiculous. I could have said, excuse me, court psychologist lady, what's happening here is that the husband is committing a first-degree misdemeanor, which is a civil crime according to the legislature, so what gives? I'm not the only one who's trying to educate people about the issues with no-fault divorce. There's a guy who's a professor at Patrick Henry College, Stephen Baskerville, and he wrote a book that's got, a third of the book is his cited resources, and it's called, Stephen Baskerville wrote, Taken into Custody, The War Against Fathers, Marriage, and Family. And he's got lots of stories in there about people who are being told they can't teach their kids what they should be able to teach their kids. Then I have another one down here. Due process is missing. Judges force divorce for no-fault grounds based in vague statutes. In law, there's a principle that you're not supposed to have laws that have words in them that are so vague that the general public don't even know what they mean. So if they had like irretrievable breakdown, when the no-fault divorces were enacted in some states, it was up to a civil judge to determine in his or her mind whether there was an irretrievable breakdown based on testimony. But irretrievable breakdown is totally vague. What does that mean? There are movements of people who stand for their marriage. They're called standers, and when someone leaves the marriage, they keep praying and hoping that he'll come back, and they do come back. People reconcile after separation sometimes. So they do come back together. So irretrievable breakdown, well, he came back. It's not irretrievable breakdown. The issue with no-fault divorce is the constitutional problem, is that according to due process, to get due process, you have to have words in the law that have meanings that are knowable. If you don't, the problem is that everyone's interpreting it differently and nobody knows what it means. So if it's criminal trespassing includes putting your car in someone's driveway, we all know what that means. But what does irretrievable breakdown mean? And then the last one here is this principle that marital misconduct is excluded as a consideration in the division of property. I talked about that a little before. In a lot of laws, and Ohio is one of them, when they do decide how to divide the property, marital misconduct cannot be considered, which is an injustice, especially for parties who married in a religious tradition. Some religious traditions have, I know from Catholic Code of Canon Law, there's jurisprudence from higher up that says if one party is committing adultery, the children should be the ones who are responsible for raising the children, because part of Christian marriage or Catholic marriage includes raising children that are morally well-grounded. So if a dad thinks that being a philandering, drunken adulterer or whatever is normal, the community wouldn't want him being responsible for the moral formation of children. So the community would want the morally grounded parent, if there is one, to be responsible for the upbringing of children. Hear this, at the expense of the guilty party. So when civil courts say, we're going to split everything up and not consider marital misconduct, that is another issue that could be raised as a constitutional challenge. So that is my list about constitutional challenges, and we've covered the Ohio law. There's plenty more resources on Mary's Advocates, but I'm not going to go in that right now. So thank you for your time. And the website is Pro Families Ohio. I am looking for lawyers that would be willing to challenge the status quo. That is, go with the Janes of the world and say to a judge, the case should be dismissed. You should not have jurisdiction over these children because he doesn't have grounds for divorce and she needs help getting necessaries. Let them use common pleas court to get money from him. And if he's an abandoner, let the criminal court say in Ohio, that's a crime. All right, thanks.